In Rimini Street versus Oracle, the court addressed whether the phrase full costs in the Copyright Act allows for a party to recover those costs of pretty much every imaginable litigation expense, or if it referred to a specific set of costs allowed for under federal law. On the one side, you had Oracle, which is a giant software company, and on the other side, you had Rimini Street, which sells its services to customers who have previously purchased Oracle software. Oracle sued Rimini Street in Nevada Federal District Court, alleging that Rimini Street had infringed a number of Oracle's copyrights for its software. This case ended up at the Supreme Court after the Federal District Court awarded Oracle a number of its litigation expenses following a jury verdict in its favor on the copyright infringement claims. Specifically, Oracle sought two separate categories of expenses. It sought, on the one hand, what are called taxable costs, which are those costs allowable under 28 U.S.C. Section 1920. And on the other hand, it sought what it called non-taxable costs, which were a litany of litigation-related expenses that aren't expressly allowed for under federal law. On appeal, the Ninth Circuit, applying circuit precedent, affirmed that award. Rimini Street then appealed to the Supreme Court, arguing that non-taxable costs were not allowable under the Copyright Act. The Copyright Act generally governs copyrights in the United States. The specific provision in question, which is located at 17 U.S.C. Section 505, allows for a court, in its discretion, to award a party quote-unquote full costs, as well as a reasonable attorney's fee if the court so decides. The difference between taxable and non-taxable costs turns on this federal statute, 28 U.S.C. Section 1920. That statute delineates 6 specific categories of costs that a party can recover. The 6 categories are really clerical and administrative costs and certain witness fees that Congress has decided to allow parties to recover. That set of costs is often referred to colloquially as taxable costs. Non-taxable costs, on the other hand, is a term used for basically any litigation-related expenses that aren't actually provided for under 28 U.S.C. Section 1920. The term full costs in the Copyright Act hadn't actually been examined particularly by the Supreme Court before this case, and a circuit split had developed. On the one hand, the Ninth Circuit, invoking the canon against surplusage, said that full costs in the Copyright Act had to mean more than just the costs allowed in 28 U.S.C. Section 1920. A number of other circuits, however, applying a clear statement rule, said that full costs was only a reference to the costs allowed in Section 1920, and that the word full did not otherwise change the default presumption that courts adopt, that costs, when it appears in federal law, refers to that list in Section 1920. The court ruled for Rimini Street. It was a unanimous decision in a short opinion written by Justice Kavanaugh. In short, Justice Kavanaugh agreed the phrase full costs in the Copyright Act did not amount to the express statement to allow recovery of those costs beyond what Section 1920 permits. Justice Kavanaugh endorsed Rimini Street's position that full costs had to be read according to normal conventions of grammar. Cost is the noun, full is the adjective. Full describes the scope of costs, but full does not expand what costs are allowable beyond what costs traditionally are. Because the court has read the word costs anytime it appears in federal law to refer to that list of Section 1920 costs, the word full can't allow for, say, expert witness fees or eDiscovery costs such as Oracle is seeking. Full simply describes the scope of those costs that are recoverable.